Thank you, Ronald. Now we are going to explore the legal aspects of physician-assisted suicide. To start, there is no consensus in the law to favor or disapprove of the practice. Today we're going to examine two cases that show just how divided the case law is when it comes to physician-assisted suicide. Oregon v. Gonzalez was formerly titled Ashcroft v. Oregon. It was a landmark case. The Oregon Death with Dignity Act, which was passed in 1994, which my counterparts mentioned earlier, gave physicians the authority to prescribe lethal doses of controlled substances to terminally ill patients. Attorney General John Ashcroft, in an effort to nullify the legislature, released an interpretive ruling in 2001 that declared physician-assisted suicide a violation of the Controlled Substances Act of 1970. For the point of this presentation, we're just going to call that CSA. Ashcroft threatened to revoke the medical licenses of physicians who took part in the practice. What's interesting about this case is that Ashcroft's argument did not focus on the ethical dilemma of physician-assisted suicide. Rather, he argued the conflict between one legislative act to another. As we go through these cases, you're going to see that pattern. The law does not consider ethics so much as the legislature. Keep that in mind as we move forward. Congress enacted the CSA as part of a comprehensive federal scheme to regulate and control certain drugs and other substances. A 1984 amendment to the Act allowed the Attorney General to prohibit medical practitioners' use of a controlled substance if that use was inconsistent with public interest. Ashcroft argued the use of controlled substances for physician-assisted suicide is not a legitimate medical purpose. The state of Oregon, in return, sued Ashcroft because of his interpretive ruling. The state asserted Ashcroft's motive was purely political under the Bush administration at the time. It was solely meant to punish physicians who practiced physician-assisted suicide. The state further asserted the administration improperly tried to use a federal drug law to prosecute Oregon doctors who prescribe overdoses. Justice Anthony Kennedy was one of the Supreme Court justices who ruled on the trial, stated Congress did not have this far-reaching intent to alter the federal-state balance. Justices on a 6-3 vote ruled in favor of upholding Oregon's position that the Oregon Death with Dignity Act does not violate the Controlled Substance Act of 1970, that physician-assisted suicide is a legitimate medical purpose. The ruling, in effect, was a reprimand to Ashcroft. Justice Kennedy said the authority claimed by the Attorney General is both beyond his expertise and incongruous with the statutory purposes and design. The ruling was later backed by a decision by the 9th U.S. Circuit Court of Appeals, which said Ashcroft's unilateral attempt to regulate general medical practices historically entrusted to state lawmakers interferes with the democratic debate about physician-assisted suicide. Ashcroft had brought the case to the Supreme Court on the day the White House announced his resignation in 2004. The Justice Department continued the case under the leadership of his successor, Attorney General Alberto Gonzales. Now we consider Myers v. Schneiderman, a case heard by the Supreme Court requesting legal relief and legalization of physician-assisted suicide. Here are plaintiffs, which were 3 terminally ill patients, Sarah Myers, Steve Goldenberg, Eric Seif, their physicians, in collaboration with the End of Life Choices New York, an advocacy group, took a more direct approach. They addressed a person's constitutional right to end their suffering. The plaintiffs sued the New York Attorney General seeking 2 forms of equitable relief. 1, a declaration that a professional who provides aid in dying to a mentally competent, terminally ill patient who has requested such assistance is not criminally liable under New York penal law. And 2, they wanted an injunction prohibiting prosecution of these professionals who aid mentally competent, terminally ill patients with the means and/or methods to end their lives. Each patient during the trial confirmed their mental competency before the court, making a request to seek aid in dying, from their personal physicians through prescriptions to achieve a peaceful death. The professionals assert they have all treated terminally ill patients who have sought their help in ending their lives. The chief argument in Myers v. Schneiderman is that patients want to determine their fates when their respective diseases cause suffering that is too much for them to bear. The professionals assert that providing such help is both medically and ethically acceptable. The physicians asked the court to remove the risk of a second-degree murder charge, as provided by the New York Penal Code, to provide this service. Our plaintiffs argued that New York laws prohibiting physician-assisted suicide violates their 14th Amendment right to equal protection. Now, just to break it down, the 14th Amendment to the Constitution asserts all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states within they reside. No state shall make or enforce any law which shall abridge the privileges of immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of laws, nor to deny any person within its jurisdiction the equal protection of the laws. This is very important because the plaintiffs argued that physician-assisted suicide is a constitutional right, that ethically their right to die is protected by our Constitution. Of course, the state rejected this assertion, claiming the plaintiffs had failed to plead a justiciable claim. The penal law cannot be construed to prohibit physician-assisted suicide. The penal law does not violate the Equal Protection Clause of the New York State Constitution, and the penal law does not violate due process. When the case came before the District Court of Appeals, their ruling took a conservative approach. They did not rule on the ethical aspects of physician-assisted suicide. Rather, they stood firm that it was a matter of legislature. The Court of Appeals first addressed the argument against New York penal codes, asserting it applies to anyone and does not exclude physicians. The Court of Appeals also rejected our plaintiffs' claims that it violates the Equal Protection Clause and due process because the court found no reason for a departure from a specific Supreme Court ruling, which was Vaco v. Quill, and it was a similar case. As for the due process clause, the court cited Washington v. Glucksberg, holding that there is not a fundamental liberty interest to committing suicide. The court noted that one's right to refuse medical treatment and to choose among medical treatments that has never been expanded to include a right to die or to get assistance from another to end one's life. Finding that the question only needed to be rationally related to a legitimate government interest, the court looked to several other cases, noting the historical trend that the state of New York itself has an interest in preventing suicide, maintaining a physician's role as healer, protecting vulnerable individuals, and preventing a slide towards euthanasia. It was a hard loss for supporters of physician-assisted suicide in New York. In closing, you have taken a journey with us to consider a very serious and dark subject. Does a person have an undisputed right to request help in their death? Does a physician who takes part in physician-assisted suicide violate their Hippocratic oath to do no harm? Is it fair that the state legislature can determine how you choose to die? Unfortunately, there are no straightforward answers. These questions walk the line between the personal and the political. Lawmakers themselves cannot agree or disagree, claiming it takes an act of legislature to make physician-assisted suicide a legal and ethical practice. What we can say is that some states and countries agree that it is ethical because it eases the suffering of terminally ill patients. Conservatives, however, disagree. As Ronald mentioned, they believe only God has that right. At the end of the day, physician-assisted suicide is an ethical dilemma that is as personal and as unique as the unfortunate individuals who have had to walk their path. So thank you very much for your time, and I hope you guys have a great day.